To keep yourself updated, subscribe to Indigo Learn and click the bell icon and download our app OneFin to start learning on the go.
Hello dear students, today we are going to be studying the General Clause Act, which is the last second chapter of your course. It is in other laws and every single attempt it comes for a good 4-mark weightage. Now let's start off with this section. We are going to be covering all the sections of this act in a quick revision form. I'm not going to be going into the details of every single section, but we are going to broadly understand every single section. Right? Let's start off with this act. So firstly, what exactly is the purpose of the General Clause Act? What is this General Clause Act of 1897? Well, see, this act was enacted on the 11th March of 1897. Before that also, there were 2 other General Clause Acts also. Now, this particular General Clause Act, as the name says, it has general clauses. Now, these general clauses are applicable with respect to other statutes if there is no specific provision in those other statutes. See, when we talk about the Income Tax Act or the Companies Act or the Indian Contract Act, the applicability of these acts is geographically defined. That means they are applicable in the entire India, they are not applicable in Jammu and Kashmir, etc. But when we talk about General Clause Act, the applicability of General Clause Act is not geographically defined. In fact, it is applicable on the central acts. In fact, it also acts as a model for State General Clause Act also. So that means here General Clause Act is applicable on other acts that are prevalent in the country. If there is no specific provision which is given in any of the other acts, then we use the General Clause Act for reference. It contains the general provisions which, if there are no specific provisions in the act, then it is going to apply. The applicability of General Clause Act is kind of secondary in nature. It is conditional. So suppose there is no specific provision in the enactment, or if there is confusion with respect to any provision, then we refer to General Clause Act, right? So accordingly, we understand what is the purpose and importance of this act. This act is basically to avoid superfluity of language in other statutes. If suppose there are certain words which do not have a definition in any other statutes, then we can use the General Clause Act definition to understand any other statute. Similarly, if suppose there is confusion in interpreting any of the sections of other statutes, we can use the General Clause Act to understand. Now, what is the applicability of the General Clause Act? As we have discussed, there is no geographical applicability. It is applicable on all the central legislations, all the acts of the Indian Parliament, also all the acts on the Dominion legislation, and also the acts passed before the commencement of the Constitution. But here it is not applicable fully. The applicability, we are going to be discussing a little bit more about it in section number 4 and section number 4A. The act is not fully applicable on the acts that were enacted before the Constitution came into the picture. Okay. But before we dive into the different sections of the General Clause Act, let's just first understand some of the basic terms. The first basic term is preamble. So what is a preamble? So what exactly is the purpose of a preamble? See, the preamble is there to define the scope, object and purpose of the act. There are so many different acts in the country. Every act is for a different purpose. For example, the Income Tax Act defines the rules of calculating the income tax. Versus when we talk about GST acts of different states, then they are to calculate the GST. When we talk about the Companies Act, then the Companies Act talks about all the rules and regulations that apply on the companies. Now, for all of these different acts, in the act itself, there is a preamble before the act starts. And this preamble basically defines what is the purpose of that act. Okay, so for example, in case of the Companies Act, the preamble says, this is an act to consolidate and amend the laws relating to companies. Very simple. The next word we are studying is definitions. Now, in any of the statute, you are going to find definitions in either section number 2 or section number 3. It may be possible that some definitions are in other sections also. Okay, now what is the importance of the definition section? See, throughout the act, there is going to be few words that will be repeated over and over and over again in different sections. For example, in case of the Companies Act, the word company is used so many times. The word officer and officer in default, they are used so many times throughout different sections in the Companies Act. Right? The word registrar of companies is also defined. So when these words are used repeatedly in different sections in an enactment, it is very important to actually define what does it actually mean. Okay, because we are talking about law, there can be disputes about even a single word and what it actually means. So therefore, in the definition section, basically, those words which are repeated throughout the act, they are properly defined as to what they include and what they do not include. So that is our definitions, right? Now, in different statutes, you are going to find different definitions. If suppose a few words, they are not properly defined in any of the statute, then the definition of that word we are going to take from the General Clause Act. The General Clause Act also has certain general definitions. Now, these definitions are only applicable if the specific statute does not define that word. For example, in the Companies Act, the word affidavit has been used, but it has not been defined. So in that case, the word affidavit, we are going to refer to the General Clause Act, and we will use the definition in the General Clause Act to interpret the word affidavit in the Companies Act. Next thing we are understanding is what is the meaning of means and includes. Now, sometimes in these definitions, the word means is used and sometimes includes words is used. Now, when we say means, it basically makes the definition exhaustive. Okay, that means that no additional items can be added in the definition of that word if means word is used. Okay, means basically limits the scope of that definition up to the words that are actually used in that definition. Okay, let's try to understand this. So here in the Companies Act, in section 2 clause 20, the word company has been defined. It is defined as a company means a company which is incorporated under this act or any of the previous company laws. So here the word means is used. So after means, there are two things written. One is a company which is incorporated in this act or a company which is incorporated in any of the previous companies acts, right? So we cannot add anything more to it. So if I tell you that a company is incorporated in Singapore, will we consider that as a company with respect to the Companies Act? The answer is no. Why? Because the definition is limited. Okay, here we are not going to add anything more. Now let's talk about includes. Sometimes in the definition, the word includes is used. This makes the definition inclusive in nature. That means more items which are similar to the words that are stated in the definition, they can also be added, right? So this makes the definition inclusive. Let's try to understand this with an example. So the word debentures is explained in section 2 clause 30 of the Companies Act. The definition reads as follows, that debenture includes debenture stock, bonds or any other instruments of the company evidencing a debt whether constituting charge on the asset or not. So here the word includes is used. So that means it includes stocks, bonds, other instruments, and it can also include additional items which are of similar nature, which are of the nature of loan. Okay, so they will all be considered as debentures. Now sometimes in the enactment, the words means and includes both are written together. Okay, means and includes. In that case, we give more preference to the word means. And accordingly, this definition becomes exhaustive. So that means it does not include anything beyond what is stated in the definition, right? Next, there are two words, shall and may. What is the meaning of shall and may? You're going to see these words a lot many times in different sections. Whereas when we use the word may, then this is a directory provision. It is not compulsory, right? So we have to be very careful when we are reading the statutes. If the word shall is used, that means this provision is compulsory. You cannot avoid it. You will have to follow it. Versus when the word may is used in any statute, it means that you may follow it, you may not follow it. It's absolutely okay. Substantially, that particular section has to be complied with. Now, sometimes in the enactment, it also happens that the lawmakers write the word may, but actually the meaning of that word should be shall. Sometimes it happens, okay? For example, we have section number 3 of the Companies Act, which says that a company may be formed for lawful purpose. Okay, here the word may has been used. Does it mean that the company can be formed for unlawful purpose also? The answer is no. So even though the word may has been used, when we are going to try to interpret this section, we will consider this as shall. So the company has to be incorporated for lawful purpose only, right? So you have to be very careful when we are reading. Generally speaking, shall represents a mandatory provision and may represents a directory provision. However, it may be possible that they are interchanged also. So you have to see the broad context of that section and the applicability of that section. Sometimes it also happens that in the same section, may and shall, both words are used. In that case, whether this whole provision is going to be mandatory or directory, how are you going to define it? How are you going to decide that? How will you interpret that section? So in that case, generally when shall and may both are used, we give more preference to shall. Okay. So accordingly, generally speaking, we consider that particular provision as mandatory. However, you will have to see the context of that section and accordingly interpret that section. Now in section 3 of the General Clause Act, there are many different definitions. We are going to be covering those definitions at the end of this chapter. First, let's discuss all the other sections that are relevant. Now first, let's talk about section number 4. It talks about applicability of certain definitions in previous enactments. Now in section number 3, there are so many different definitions given. Now all these definitions are applicable on all the central acts that are created after 1897. But what about the applicability of these definitions on the previous acts that were created before 1897? Now, when we talk about General Clause Act, there are 3 different General Clause Acts that have came into the picture. The latest one that we are studying is the 1897 Act. Before that, there was an act in 1887 also. And before that, there was an act in 1868 also. right? These were the three different general clause acts that came into the picture. Okay, now for the acts that are, for the central acts that are created after 1897, all the definitions which are stated in section 3 of the General Clause Act will apply. But with respect to the enactments that happened from 1868 till 1897, there is partial applicability of the definitions which are given in section number 3. Some definitions are applicable only with respect to central acts that are created between 1868 and 1887, and some definitions are applicable only with respect to the enactments that happened between 1887 and 1897. So what are these definitions? Let's see that. That is stated in your section number 4. So section 4 says that the meaning of the word affidavit, immovable property, imprisonment, month, movable property, oath, person, section, year, they will be applicable on all the central acts that were made from 3rd January 1968 to all the regulations that are made till the 14th January 1887. Okay, so these are the definitions which are to be applicable on the central acts that are made from 1868 till 1887. Okay. Now some other definitions, that is the word commencement, financial year, offence, registered, schedule, subsection, writing, these words, their definition in the General Clause Act is applicable with respect to central acts and regulations made on or after 14th January 1887. So this section simply defines the applicability of certain definitions on the different enactments that came out. The next section we are discussing is section number 4A, which talks about applicability of certain definitions on Indian laws. What is Indian laws first of all? Indian laws means those statutes that came into the picture before our constitution became valid. So that is before 1950, before the Republic Day of 1950, any enactments that were there with respect to them in the General Clause Act, which all definitions are applicable, that is stated in our section 4A of the General Clause Act. This section says that the word central act, central government, gazette, government, government security, Indian law and official gazette, the meaning of these words stated in the General Clause Act, they are going to be applicable on all the Indian laws. That means all the statutes that came into the picture before our constitution. Next, let's talk about some general rules of constructions. They are given in section 5 to section 13 of the General Clause Act. First of all, let's talk about section number 5. Section 5 talks about coming into operations of the enactment. How an enactment comes into the picture. What is the effective date of an enactment, that is stated in our section number 5. Now, first of all, how an act is created. See, first of all, the bill is drafted. So there is an expert committee that sits down. They write down a draft bill. So according to them, whatever should be the laws, they write it down in the draft bill. Then this draft bill goes to the parliament. It has to be passed by both the houses of the parliament, that is Lok Sabha and Rajya Sabha. Once they are passed, then they will have to be taken to the president. The president is going to sign on this document. That is, our draft bill is going to be finalized by the sign of the president. Right? And after that, it is going to be published in the official gazette. Right? Now, when it is published in the official gazette, it may be possible that in that notice of publication, it is stated that this act is going to be applicable from so and so date. It may be possible. If there is a date like that, then we are going to consider that date as the effective date. But sometimes it happens that in the official gazette, the notice does not mention the effective date. If an effective date of the act is not mentioned, then when are we going to consider that act to come into the picture? Well, in that case, it is going to be applicable from the date when the president gives the assent on that bill. So if suppose any specific date is mentioned in the notice of official gazette, then that date is going to constitute as the effective date of that statute. If there is no date mentioned, then in that case we are going to see when the president signed on that bill, and that is going to be the date on which this act came into the picture. The effective date is going to be the date of signing of the president. Now, always we have to assume that the act is going to be prospective and not retrospective. Okay, whenever we are trying to find out the date on which the act is going to be effective, we will always assume it to be prospective, not retrospective. Now, what is the meaning of prospective and retrospective? When we say prospective, that means the date which is mentioned, after that, whatever actions happen, the act is going to apply on those actions, right? So basically the applicability of the act is defined by that date, and after that it is going to be applicable. Prospective means after a particular date. When we say retrospective, it means from a previous date it is going to be applicable. So let's say there is a new act which is enacted. Now the date in the official gazette is stated that this particular act is going to come into the picture on the 1st January of 2022. Right? In that case, we are going to assume that this act is prospective. So that means all the actions done after 1st January 2022 is going to be covered by this law. But it may also be possible that in that enactment, it is very clearly stated, or in that official gazette, it is very clearly stated that even though this act is coming into the picture on the 1st of January of 2022, it will have a retrospective effect from 1st January 2021. Okay, in that case, it means that that particular act will be applicable not only on the actions done after 1st January 2022, but they will also be applicable with respect to all the actions done from the 1st January 2021 till 1st January 2022. Okay, so this is called retrospective applicability. Retrospective applicability means the act is coming later, but it is applicable from a previous date, right? So whenever an act comes into the picture, we will always assume it to be prospective. Okay, until and unless it is very clearly stated that it will have retrospective effect from a previous date, otherwise we are not going to consider it as retrospective. We will always consider it as prospective. The next section we are doing is section 6, effect of repeal. Now what is repeal? Repeal means cancellation, okay, complete deletion, right? So if suppose there is an act, it may be possible that the government decides that this act is absolutely useless, it is not relevant anymore, they might decide to repeal this act. For example, the Wealth Tax Act, okay, it was no longer required, so the Wealth Tax Act was repealed. When we say repeal, it means it's fully cancelled out. That means no longer any actions will be governed by that law. Okay, but whenever a law is repealed, whenever a particular provision is also repealed, it has some effect. What are those effects? They are stated in your section number 6. Section 6 says that in case of complete repulsion of an act, then also whatever effects it had previously, they are not going to be removed. So if some person was punished under that act, he will continue to have that punishment. If certain property was forfeited, or there was penalty, or there was any offense committed, then that is going to continue, right? Whatever has happened according to that act, it cannot be revived back. It will not affect the prior management of the legislation. It will not affect any claims, privileges, responsibilities, debts obtained according to that particular act. It will not affect any inquiry, litigation, remedy with regard to that particular act. So if there is any case also pending with respect to that act, it is going to continue. If someone got jail or penalty, it is going to continue. If someone got a particular property because of that act, it is going to continue. Whatever effects happen because of that enactment, they will still continue to happen. However, that act is completely cancelled out, it is repealed. If suppose it is an act, then in that case, it will no longer be further applicable. Next section we are seeing is section number 6A, which talks about repeal of act, making textual amendments in an act or regulation. Now what does this section say? This section says that where an enactment was useful for the purpose of the provision of another enactment, and the first enactment is repealed, then in that case it shall not affect the relevant provision in the second enactment, and it shall be amended to fit the repeal unless a different intention appears. Now what does this mean? Let's try to understand this with an example. Suppose we have one act and there's another act. Okay, now in this first act, there is some provision which is stated. Now in this provision, a reference is made to another act, which is act number 2. Okay, now whenever we are trying to interpret that provision of act number 1, we will refer to act number 2 also, because act number 2 has been referred to in act number 1, right? Now let's say this act number 2 is repealed, it is cancelled out. In that case, does it mean that in act number 1 also relevant provision is cancelled? The answer is no, that relevant provision is not cancelled. But how are we going to interpret it? See, this relevant provision requires us to see act number 2. Now the act number 2 is cancelled, but just for the purpose of interpretation of act number 1, we can still use the reference which is given in act number 2, even though act number 2 has been repealed. Okay, so this is a very simple section. However, if suppose the intention of the act is different, in that case we will have to modify our interpretation. The next section is revival of the repealed act, section number 7. Now this says that in order to revive a repealed statute, it is necessary to state the intentions to do so, right? So this simply says that whenever an act is repealed, then if suppose this act is brought back, then the government should state why they're bringing it back. So we know the Wealth Tax Act is cancelled out, it is repealed. So if suppose the central government wants to bring it back, then it is important that the central government should explain why they cancelled it and why they're bringing it back. Next section is section 8, construction of references to the repealed enactments, where part of the repealed enactment is revived with or without modification. References in any other enactment or instrument to the provision so repealed shall be construed as reference to the provision so re-enacted unless a different intention appears. What does it mean? Let's try to take the same example. We have act number 1 and act number 2. Now act number 1 uses the reference of act number 2. and Act number 2 has been repealed. Now let's say that Act number 2 has been revived back. Okay, so it was first of all repealed, now it has been revived back with some sort of modifications. In that case, how are we going to interpret this Act number 1? See, in Act number 1, it may be possible that the language of Act number 1 still refers to Act number 2, the older version. Okay, but here, because that older version of the Act is repealed and the new Act is enacted, therefore, we are going to refer to the new Act, which is Act number 2, which is the reenacted one. We will have to refer to that in order to interpret Act number 1. Okay. One example of this would be the Income Tax Act. In the Income Tax Act, many places there is a reference of the Companies Act 1956, which was there. Now it is not there, but previously at many different sections, Companies Act 1956 was mentioned. But the Companies Act 1956 was repealed. In fact, in place of that act, Companies Act 2013 was brought, right? So there was an act which was repealed and a new act came into the picture in place of that old act. Now, in Income Tax Act, however, for a good amount of time, that old act was only referred. Companies Act 1956 was referred, even though there was this new Companies Act of 2013. In that case, how are we going to interpret the Income Tax Act? See, with respect to that, this section, our section number 8 says that if the reference act is repealed and reenacted, we have to use the reenacted version of that act. We have to use the relevant provision in the reenacted act. So in Income Tax Act also, even though reference was of 1956 Act, we will have to use the 2013 Act for interpretation purpose. The next section we are seeing is section number 9, which talks about commencement and termination of time. This section says that whenever there is a time period which is given in any statute, then the first day of the series of days is to be excluded and the last day of the series of days is to be included. Now what does this mean? Let's try to understand with an example. So in the Companies Act, we know that once a dividend is declared, it has to be paid within 30 days, right? Now let's say the dividend is declared on the 1st of January of 2022, right? Can you calculate by what date it has to be paid? So see, we have to calculate 30 days. Now when we calculate 30 days, the first day has to be excluded and the last day has to be included. So we are going to calculate from 2nd January, 3rd January, 4th January, 5th January and so on. So the date that is going to come is, it is going to be the 31st of January. So till the 31st of January, we will have to ensure that the company pays the dividend. So that is going to be 30 days from declaration. The next section is section number 10, which talks about computation of time. It says that where any legislation, regulation, act or proceeding is to be done in any court, office on a certain day or within a prescribed time, and if the court or office is closed on that day or the last day of the prescribed period, then the act of the proceeding shall be done or taken in due time on the next day on which the court is opened. Okay, so if suppose there is a proceeding that has to happen in the court or in the office, and on that day when the proceeding has to happen, there is a public holiday, the court is closed. In that case, we will consider that proceeding to happen on the next day when the court is open. Simple. Now let's try to understand this with a small example. Suppose in the High Court there is a hearing that has to happen. Okay, now this hearing, let's say it is happening on the 24th of March of 2020, but the government has declared lockdown and the lockdown happens for good 6 months. Okay, in that case, can we say that the last date of this hearing will happen after the lockdown is over? The answer is yes. So if suppose there is a public holiday on the last date when the proceeding has to happen, then on the next day after the holiday, we are going to take up that proceeding. Alright, the last day is going to be extended till the next day the court is open. Next section is section number 11, measurement of distance. It says that in an act, whenever a distance has to be measured, it has to be measured in straight line on a horizontal plane, not in a zigzag manner. This is very simple. So if in a statute it is stated what is the difference between point A and B, calculate that, and based on that the duty is going to be calculated or penalty is going to be calculated. If suppose distance has to be calculated from 2 points, then in that case the distance has to be calculated in a straight line on a horizontal plane. Next section is section number 12, duty to be taken in pro rata in the enactment. This section says that if any duty is liable on any given quantity, weight, measure or value of the goods or merchandise, same duty shall be applicable on higher or lower quantity in proportionate basis. So whenever a duty is mentioned in any statute, then if suppose the quantity is increased, value is increased or decreased, anything, then we will have to calculate the duty on proportionate basis or pro rata basis. Let's try to understand with an example. So suppose there is an act which says that 100 rupees duty is going to be payable on goods value of 10,000 rupees. In that case, if suppose the goods value of 20,000 rupees are there, in that case the duty is going to be pro rata basis. So if on 10,000 rupees of value the duty is 100 rupees, then on 20,000 rupees of value of goods the duty is going to be 200 rupees. So the duty, penalty, whatever it is, it has to be calculated in proportionate basis, in pro rata basis, based on whatever is stated in the statute. The next section is also very simple, gender and number. Section number 13, it says that in a legislation, if masculine gender is mentioned, then it will include females also. If singular is mentioned, then it will include plural also, and vice versa, right? It means that let's say in a particular enactment, it is stated that he shall be liable to penalty of so much money. In that case, he is a masculine gender. Does it mean that the women will not be included? They will not be punished if they have done the same offense? The answer is no. So this section says that if in any statute masculine gender is used, then this automatically includes the feminine gender also. If the females have also done the same kind of flaw, the same kind of offense or same kind of crime, or same provision is applicable on the females also. Same way, if suppose in an enactment singular word is used, then it is going to include plural also, and if suppose plural is used, then singular will also be included. For example, let's talk about the income tax authorities. So the income tax authorities have the power in the Income Tax Act that if they think that someone has not paid the taxes, if someone has black money, if they're hiding the cash, then they can do a raid on the property of that person. So this is the power which is given by the Income Tax Act to the income tax authorities. Now, does this mean that every single day the income tax authority is going to go and do a raid on different people? The answer is no. So here, when the power is given by a statute to the authority, the power is going to be exercised from time to time depending on the requirement of that power, right? So here also, if suppose the income tax authorities, they genuinely think that someone has stolen tax, someone has black money, someone has excess cash hidden, then in that case, the raid can be done by them, right? So that is what this section says. Let's move on to the next section. The next section is power to appoint, to include the power to appoint an ex officio. This is given in your section number 15. Now, this section basically says that if in a particular statute, the power is given to appoint somebody, then the appointment can be done with respect to ex officio also. So that means an ex officio can also be appointed if suppose the power is bestowed by the statute to appoint someone. Now, what is exactly the meaning of ex officio? Now, when we say ex, we generally think it is past. But ex officio does not mean some past officio. Ex officio basically means a person who is appointed because of his position in the organization, even if that person is not exactly qualified. Then also, if suppose that person is holding a position in that organization, then that person is called ex officio. So whenever in a statute specifically the power to appoint is given, then appointment can be done of a person who is qualified, or it can be an ex officio who can be appointed. The next section is section number 16, which talks about power to appoint, to include the power to suspend or dismiss. Now this section says that if suppose in a statute there is a power given to an authority to appoint a person, then that power also includes the power to dismiss or suspend. Now sometimes it happens that in a statute there is only specifically a power given to appoint a person. It is nothing stated in that statute with respect to removal of that person from that position. So in that case, we are going to assume, according to section number 16, that if suppose a power to appoint is given, then automatically the power to dismiss or suspend will also be assumed there. So the authority will also have the power to suspend or dismiss. The next section we are discussing is section number 17, which talks about substitution of functionaries. This says that if generally the function is performed by one person, one authority, and suppose in place of that authority someone else is performing the functions, then that other person has to mention that they are not the exact original person. They have to mention the authority that they hold. And if they do so, then the same laws that are applicable on the main person, they will also be applicable in case of this substitute person, right? So that means if a function is supposed to be performed according to a statute by the main person, it can be performed by a substitute also, as long as that substitute mentions that they are a substitute. Okay, and in that case, the same laws are going to be applicable on the substitute as well. For example, where the minutes of the general meeting are signed by the vice chairman instead of the chairman, he shall specify the position along with that, right? So we know that in the general meeting, whatever proceedings are happening, they have to be written down in the minutes of the general meeting. Now, who signs the minutes of the general meeting? The chairman of the general meeting signs the minutes of the general meeting. Now, let's say the chairman is not available, and in place of the chairman, the vice chairman is signing these minutes. In that case, the vice chairman has to mention below that he is the vice chairman, right? Accordingly, all the laws will also be applicable on this vice chairman. The next section we are discussing is successors, which is section number 18. Now, this section says that in a statute, if suppose it is mentioned that the organization will have perpetual succession, then in that case, in the statute, it should also be mentioned how the perpetual succession is going to operate, right? So, for example, in the Companies Act, we know that company has a separate legal entity. The company does not die. It is working on going concern basis. So, even if all the members of the company, they die, still the company is going to exist. Okay, so this is called perpetual succession, right? Now, when we say that company is going to enjoy perpetual succession, then how is it going to enjoy perpetual succession? We also have to define that, right? So, in the Companies Act, it has to be mentioned how it is going to be done. Okay, so we know for the company, if suppose all the members have died, then the nominees of the members, they are going to take over the place of the members, right? So, whenever in a statute it is stated that perpetual succession is going to happen, then it is also necessary to state how it is going to happen, right? The next section we are discussing is section 19, official chiefs and subordinates. Now, this section is very simple. It says that if certain statutes and laws are applicable on the superior, then they will also be applicable on the subordinate. Very, very simple, right? So, in case of income tax, if suppose the higher income tax authorities have Income Tax Act applicable on them, then if suppose they delegate those powers to any subordinates, then on the subordinates also the act is going to be applicable. Very simple section. Next, we are talking about certain provisions as to order rules that are made under the enactment. Okay, section 20 to section 24 of the General Clause Act. First, let's talk about section number 20, which talks about construction of the orders issued under the enactment. Now, if suppose there is an act, with respect to the act, there are certain rules that are always prescribed. For example, with respect to Companies Act, we know there are so many different rules that we have to study. With respect to every chapter of the Companies Act, we have to study rules also. For example, for incorporation chapter, we have this incorporation rules. Similarly, for management and administration also, we have management and administration rules, right? So, when we are trying to interpret these rules, then certain words are mentioned in the rules. Now, these words are common words that are also stated in the act, right? So, what should be the meaning of these words? So, with respect to that, section number 20 says that if suppose there are certain words which are used in the rules, then the meaning of that word is going to be construed the same as its meaning for the act. For example, in the Companies Act, we have this word company which is used multiple times, right? This word company is stated in section 2 clause 20 of the Companies Act, right? The meaning is defined in that section. Okay. Now, when this word company is used in any of the rules relating to Companies Act, then also we construe the same meaning which is stated in section 2 clause 20 of the Companies Act. So, basically the meaning of the word is considered same in the main act also and it's in its respective rules also. So, that is what our section 20 says. Same way, if suppose with respect to any particular act, there is any notification, order, scheme, rule, form or bylaws that are issued, then the words that are used in such documents, they will be construed to have the same meaning as in the main relevant act. Next section is section 21, which talks about power to issue to include the power to add, amend, vary, resign notifications, orders, rules, bylaws. Now, this section basically says that if suppose in a particular statute, there is power given to the authority to issue any notification, then in that case, that power to issue the notification will also include the power to amend the notification or vary the notification or resign the notifications, right? Or make any changes to the notification. Very simple, right? It is applicable on notifications, orders, rules, bylaws. Let's try to understand with an example. So, in the Companies Act, we have the power which is given to the MCA, which is the Ministry of Corporate Affairs, or we can also call the central government. The central government has the power that if they want to change any of the sections of the Companies Act, then they can issue notifications. Let's say the Companies Act, let's say a particular section of the Companies Act has to be changed. Accordingly, notifications have been issued. Okay. Now, can the central government change this notification? The answer is yes. Okay. In the Companies Act, it is merely stated that the notification can be issued to change the section. But here, according to the General Clause Act, section number 21, this power to issue the notification also includes the power to change that notification or to withdraw that notification or to vary that notification or to resign that notification, right? So, here the central government has the power to make changes in that notification also. Same way, if suppose any rules are issued, bylaws are issued, orders are issued, then they can also be changed or they can be varied or they can be rescinded. Next section we are discussing is section 22. Making of the rules of the bylaws and issuing of orders between passing and commencement of the enactment. Now this section says that if suppose any rules are issued after the passing of the act but before the commencement of the act, in that case what is going to be the applicability of those rules? That is what this section is discussing. Let's try to understand this with a small little example. So suppose there is an act which comes into the picture on, let's say, 1st of January of a year. Okay. Now here this act is brought into the picture, but let's say the official gazette specifically says that this act is going to be applicable from the 1st of April of 2020. This is a hypothetical example. So we are saying that this particular act is going to be applicable from the 1st April of 2020. Now whenever an act comes into the picture, with respect to that act, there are certain rules also that are prescribed. Okay. So let's say the rules are also specified with respect to the act. But what happens is that these rules are created and they are published before the commencement of this act. Let's say these rules are published on the 1st of February of 2020. Now the question is that with respect to these rules, how are they going to be applicable? Whether these rules are going to be applicable from the 1st February or whether they are going to be applicable from the 1st April of 2020. Well, here this particular section, which is section number 22, it says that in case of any statute, if suppose the rules have been published before the commencement of the act, then also the rules will be applicable from the date when the act is applicable. Okay. So see, the act runs parallel with the rules. So rules generally contain the procedures to comply with the act. So if suppose there is no act, then there is no point of having rules also. So if suppose the rules come into the picture before the statute, in that case the rules will be applicable from the date when the statute is applicable. In this case also the rules are going to be applicable from the 1st April of 2020 and not before. Now this particular section is applicable on the rules or any bylaws or any orders which are passed with respect to an enactment. They are going to be applicable from the date when the statute is applicable. Next we are taking section number 23, which talks about the provisions which are applicable to making of the rules and bylaws after previous publication. So with respect to any act, if suppose any rules are to be created or bylaws are to be created, then what is the procedure that the government should follow? With respect to that, we have section number 23. Section 23 says that first of all, a draft will be created. Draft means a sample of the bylaws or a sample of the rules. So an expert committee is going to sit down, according to their knowledge they are going to draft the rules or the bylaws. Once they are drafted, then they are going to be published in the public domain. They are going to be available for access to any of the experts in real life situations. Then after that, once it is properly published, then the objectives and suggestions which are there, which the people want to give with respect to those bylaws and rules, they will be taken. With respect to that, a date will be specified. Very clearly a date will be specified. Up till that date, if suppose anybody has to give any sort of suggestions or objections, they can give those objections and suggestions. Now these objections and suggestions are going to be considered by the expert committee. And finally, the final rules and the bylaws are going to be published in the official gazette. Once these are published in the official gazette, then they are going to be conclusive proof that the rules and bylaws have been duly made. Okay. So this is a very simple procedure. Next section is section number 24, which talks about continuation of orders issued under enactments repealed or re-enacted. Now this section says that if suppose previously there was an act and with respect to that act there were certain specific rules that were created. Okay. Now this one act was repealed, it was cancelled out, and then later on this same act was re-enacted. This repealed act was brought again into the picture. In that case, this new act will also have certain rules that the government is going to make. Now let's say in this revived act with respect to certain matters, the rules are not made. Can we refer to the rules of the previous repealed act? The answer is yes. So here section number 24 says that in case a repealed act is revived, then if suppose in the revived act with respect to certain matters rules are not available, then we are going to refer to the rules with respect to those matters which are given in your repealed act, right? Simple. Let's say we are talking about the Companies Act 1956. We know this act is repealed and in place of this act we have the Companies Act of 2013. Right? Now let's say in the Companies Act of 2013 with respect to certain matters the rules are not available. In that case, can we use the rules with respect to those matters which were given in Companies Act 1956? The answer is yes. That is what this section says. Now here this section is not only applicable on the rules, but it is also applicable for notifications, orders, schemes, forms or bylaws. Next, we are seeing certain miscellaneous sections. The first one is section 25, which talks about recovery of the fines. Now, this section says that if specifically in an act it is stated how the fine is going to be recovered, then we are going to use that statute. If suppose specifically it is not mentioned in any statute how to recover the fines and penalties from a person, then in that case we are going to use section number 63 to section number 70 of the Indian Penal Code and the provisions of the Code of Criminal Procedures to recover the fine and penalty. Okay, what does this mean? It means, let's say under the Income Tax Act, there's a person who has stolen tax. Okay, he has not paid the tax. So now he is required to pay the tax. Okay, the authorities have given an order to this person, he is required to pay the tax. But he says, listen, I am not going to pay the tax, do whatever you have to do. In that case, we are going to follow the provisions which are stated in the Income Tax Act to recover the penalty and the fine along with the tax which this person has evaded. Now, income tax authorities specifically mention the procedure to recover the taxes or the fines and the penalties from this person. However, it may be possible that in some acts, it is not very clearly stated how to recover these penalties. If a person simply refuses to pay the penalty or the fine, how are we going to recover it? So, in that case, we are going to refer to General Clause Act section 25. Now, this section says that in such a situation where the statute is silent, we are going to use section 63 to section number 70 of the Indian Penal Code and the provisions of the Code of Criminal Procedure to recover any fines or penalties due from that person. Next section is section 26. Provisions as to offence punishable under 2 or more enactments. Now, this section is very simple. It says if suppose a person has committed a crime or an offence which is punishable under more than one act. Okay, so 2 or more enactments specify that this person is to be punished. In that case, he has to be punished only one time according to both of these enactments, right? So, the offender shall be liable to be prosecuted and punished under either or any of those enactments, but shall not be punished twice for the same offence. For example, let's say we have a person, this person has taken bribe, okay. Now, when a person takes bribe, this person is liable under the Indian Penal Code also. Along with that, also under the Prevention of Corruption Act, this person is going to be punishable, right. Now, here this person is punishable under 2 different enactments. So, in that case, are we going to send him jail 2 times? The answer is no. Okay, so here this person has to be punished, he has to be punished once only, he has to be prosecuted once only according to either the higher penalty or according to the combined penalty of these 2 enactments, but this person is not going to be punished 2 times. Next section we are discussing is section number 27, meaning of the service by post. Now, this section talks about what is the correct way of sending a notice by post. Now, this section is applicable if in a particular statute there is no specific section talking about service of notice by post. Okay. So, now this section says that the service of post is going to be considered proper if it is properly addressed, it is prepaid and it is posted by registered post. What is it? First of all, it has to be properly addressed. So, the person who has to receive this notice or letter or document, his address should be properly written on this post. The second thing is properly it should be paid. So, the person who is sending this letter or notice to a person, he should properly pay any charges relating to sending this notice. And thirdly, it should be sent by registered post. Okay. So, these are the 3 conditions which have to be followed. If these 3 conditions are followed, then we are going to consider it as service by post which is properly done. Now, please note, this section is applicable only if any particular statute does not have any specific provision relating to service of notice. For example, in the Companies Act, we have specifically section number 20 which talks about service of notice, right. In that case, for Companies Act, we are going to follow what is stated in section number 20. We will not use the General Clause Act section number 27. However, if suppose any other enactment does not talk about service of notice by post, we are going to use this section. Let me ask you a quick question. So, suppose in a particular enactment, it is stated that the notice has to be sent by registered post acknowledgement due. In that case, are we going to use that section? Let's say a person has sent the notice by simply registered post. Can he say that as per section 27 of the General Clause Act, he has done right and this notice should be considered as properly served? Well, in this case, the answer is that General Clause Act will not be applicable. In this case, because there is a specific statute which says specifically that the notice has to be sent by registered post acknowledgement due. In that case, merely registered post as per General Clause Act will not be sufficient. We will have to follow what is the specific provision relating to that in that specific statute. Next section is section number 28 which talks about citation of enactments. Now, what is citation of enactment? Now, see, sometimes when you create notes, in the first page of the note probably you define a particular term nicely. Now, it may be possible that the same word is used after 5 pages or 10 pages. In that case, on that 10th page, do you actually define the entire definition again? No. You probably just put a star and you write that this definition has to be referred from page number 1. So this is called citation. Okay. So on one page, you are basically doing a reference with respect to another page. So basically, in order to read that page, we will also have to read this other page. Right. So the same way in an enactment also sometimes it is done that in a particular section it may be possible that there is a word, it has to be defined, it has to be understood. In order to understand that definition, it is put a star in that enactment and it is stated that the definition of this word has to be taken from this other statute. Alright, so this is called citation of another enactment. So sometimes it happens that when we start reading one act, we sometimes have to refer to multiple other acts also because there are so many different citations from different enactments in that act. So in order to properly understand this act, we have to refer to multiple other acts. This is called citation. Okay. Now this particular section says that if suppose there is a citation in one act with respect to another act, then we are not going to take that other entire act to understand this act. We are only going to use that particular reference. Okay. So for example, in the Companies Act, there is this word security which is written many times. Okay, and this word security has been defined to include the definition which is stated in the Securities Contract Regulation Act. Okay, so this word securities in the Companies Act, it means what is the meaning of this word in this other act which is the Security Contracts Regulation Act. Now here, whenever we have to understand the Companies Act, this word has to be interpreted as its meaning given in the SCRA. Okay, but it does not mean that the entire SCRA is also applicable on the Companies Act. Right. So when we talk about citation, we only have to refer to that particular meaning. We do not have to take the entire act in this one act. That is what this section says. Next section is section number 29, which talks about saving of previous enactments, rules, bylaws. Now this section says that after this General Clause Act came into the picture, if any new acts come into the picture, they will be construed according to the General Clause Act. But this particular act is not going to affect the construction or interpretation of any of the previous acts which are amended or altered after this General Clause Act came into the picture. Right? Simple. Next section we are discussing is section 30, application of Act to ordinances. This is the last section of the General Clause Act. Now this section basically says that this entire General Clause Act, it is going to be used for the interpretation of ordinances also. Okay, so just like how we use the General Clause Act to interpret any central acts or rules, same way if suppose any ordinances are also issued, then with respect to interpretation of the ordinances also, we can use the General Clause Act. Now what is this ordinances actually? You understand? So see, whenever a statute has to be brought, then it has to be passed by both the houses of the parliament. Now see, the houses of the parliament, they are not always in session. Sometimes they are in session, sometimes they are not in session. So let's say between two sessions of the houses of the parliament, there is the need of a law, there is a need of an amendment, there is a need of a notification that has to be passed with respect to a statute. In that case, what happens is that simply the expert committee, they write down a draft of that notification. They write down the draft of that amendment and it is directly handed over to the president, and then the president signs on that particular draft, making it an ordinance. So once the president signs on that draft notification or draft amendment, then that amendment or that statute becomes an ordinance, right? So this ordinance is valid and applicable on the citizens only till the next session of parliament actually sits down. Okay, let me repeat, between two sessions of parliament, if suppose there is a need of any law, then the expert committee sits down, they create the law, they give it to the president signs this law, it becomes an ordinance, and this ordinance is a valid law till the time the next session of the parliament sits. Now once the next session of the parliament sits, then they are going to review this ordinance and they may pass this ordinance or they may reject this ordinance, right? So that is called ordinance. So this is basically a temporary law between the sessions of the parliaments. So with this, we have completed all the different sections of the General Clause Act, but we still have to do the definitions. The definitions are covered in your section 3 of the General Clause Act. Let's read all the definitions which are stated in your study material. The first one is section 3 clause 2, which talks about act. Okay, now when we say act, it means the action which is done. Okay, it does not mean any statute. It is actually an action which is done. Okay, so when we say action to be done, then it may be an act which is done or any forbearance to do an act. That means not to do an act. Both of these things are covered in action. For example, if I tell you to study, then that means if you study, it is an act done. Whereas it may be possible that I tell you not to go out and play. right? In that case, I'm asking you not to do a particular thing. That will also be considered as an act. Now, when we say act, it also includes any illegal omissions. When we say omissions it means that someone has forgotten to do something. That is called omission. If someone has forgotten to do something and it was legally supposed to be done, that means it is an illegal omission. So, illegal omission will also be considered as act. For example, if someone wrongfully neglected or refused to supply food to a person, in that case, that is going to be considered as illegal omission. So, for example, if a person is dying and the person needs food or water and someone completely omits to provide that, then this is illegal. This is illegal omission. This is going to lead to the death of a person. So, this is also going to be considered as act. Next is clause 3, which is affidavit. What is an affidavit? Okay, so you must have seen a legal paper which has a small currency note on top of it, and then under it there is a declaration. I, so and so, declare so and so. It is stated. So, there is sometimes a declaration which is stated on a legal paper and then someone signs it. So, that is called an affidavit. So, instead of an oral word, if someone is putting it down on a legal paper, it is considered as affidavit. So, it shall include any affirmation or declaration in case of a person by law allowed to affirm, declare instead of swearing. Simple. Next is clause 7, which is central act. Now, the entire General Clause Act is applicable on central acts. So, what is a central act? Central act means all the acts that are created by the Parliament after the Constitution was created. That means after 26 January of 1950, all the acts that were created, they are considered as central acts. Apart from that, before the Constitution was created also, before that, whatever acts came into the picture, they will also be considered as central acts. The next clause we are checking is clause number 8, which defines central government. So, what is central government? Again, here the meaning of the word central government is also before the Constitution and after the Constitution. Now, before the Constitution, we had Britishers who were ruling. So, at that time, there used to be a Governor General. Along with that, there used to be a Constituent Assembly, right? So, that used to be considered as central government. Along with that, there were some states that were ruled by provincial rulers. So, in that case, the provincial rulers will be considered as central government with respect to the time before the Constitution came into the picture. And sometimes there were certain states which were commonly ruled by the Britishers as well as they were also ruled by the provincial rulers. So, in that case, sometimes chief commissioners were appointed. In that case, the chief commissioner is also going to be considered as central government. So, this was all before 1950. Now, after 1950, we know we have the president, we have the parliament, we have state government, we have union territory governments also. All of these are constituted as central government as per our definition in clause number 8. Next clause is clause number 13, which defines commencement. What is commencement? Commencement is used with reference to an act. The date on which the act actually commences, it becomes effective. That is considered as commencement. It is applicable for acts as well as regulation and rules. The next is clause number 18, which talks about document. Now, document is, it includes any matter which is written, expressed or described upon any substance by means of letters, figures, marks, or by more than one of those means which is intended or used for the purpose of recording that matter. So, what is document? When we write something on an object in order to record a matter, then this is simply called as document. The next clause is clause number 18, which defines document. So, what is document? If suppose anything is written or expressed or described on a particular substance by means of letters, figures, marks, or more of these things for the purpose of recording that matter, then it is called document. So, these 4 features have to be in a document. When we say document, then something is written in the form of figures or language on a substance. This substance could be paper, it could be a painting, it could be stone also. And the main purpose of writing this is to record that matter. Simple. So, it has to be in writing. It can be on any substance and the purpose is recording matter. The next clause is clause number 19, which says enactment. Enactment shall include any regulation or any act made by the Union Parliament or the state legislation. So, when we say enactment, what is the meaning given in General Clause Act? It means any law which is passed by the central government or the state government. Simple. Next clause is clause number 21, which talks about financial year. Now, this is an important definition with respect to your examination. So, what is the meaning of financial year? See, according to General Clause Act, financial year is the year which commences on the 1st of April. Alright. So, that means it starts on the 1st of April. So, if a year starts on the 1st of April, it is going to end on the 31st of March. So, that becomes your financial year as per the General Clause Act. Now, please note, with respect to all of these definitions that we are discussing, in any statute, if the specific word has not been defined, then we are going to refer to these definitions. We do not have to use these definitions if these words are already defined in a statute. For example, in the Companies Act, we know that financial year has already been defined. And there in the Companies Act, financial year is the year which ends on the 31st of March. Right? So, because the Companies Act already defines the financial year, therefore, we do not have to use this definition given in the General Clause Act of the financial year. Okay. Now, however, if suppose in a statute this word financial year is not defined, then we are going to use this particular definition. Now, please tell me whether there is a difference between the calendar year and the financial year in the General Clause Act. The answer is yes. Now, when we say calendar year, that means we are talking from the 1st January till 31st of December. Whereas, when we talk about financial year in the General Clause Act, then this is the year that starts on the 1st of April. So, it is going to end on the 31st of March. So, there is a difference between the calendar year and the financial year. This is actually a question from your examination. The next section is section 3 clause 22, which talks about good faith. Again, this is a very important definition with respect to your examination. Sometimes, what is the meaning of good faith? That is directly asked. So, what is the meaning of good faith? A thing shall be deemed to be done in good faith, which is in fact done honestly, whether it is done negligently or not. So, if a person is honestly doing something, then it is going to be considered as good faith. Now, here the question is, let's say a person is purchasing a watch. Now, he does not take care of the quality of the watch. He simply purchases that watch. Later on, he finds out that this watch is actually not working. Okay. In that case, can we say that this watch was purchased in good faith? So, here the important point is, if suppose a person makes a purchase, makes a transaction without due care and attention, he is not diligent. Okay. He simply purchases something or does a transaction. Can we call it as good faith? The answer is no. So, if suppose a person is negligent, a person is not taking due care and attention while doing a transaction, then we cannot consider that as good faith. So, in this particular example, if this person is buying a watch without checking the watch, then this will not be considered as good faith. So, this is an exam question. Next clause we are discussing is clause 23, which talks about government. What is government? So, government means central government as well as state government. Simple point, central government as well as state government both are included in the definition of the word government according to the meaning of government given in General Clause Act. So, here if the word government is used in any of the statutes, then if it is properly defined, we are going to use that definition. Otherwise, we are going to use this definition which is stated in our General Clause Act. The next clause is clause 24, which talks about government securities. What is government securities? Government securities means any securities which are issued by the government. And what is government? Government can be central government or state government or any union territory governments also, right? Simple. So, if suppose the central government, state government or any union territory governments, they issue any securities, it could be bonds, it could be notes, then they are going to be considered as government securities. The next definition is in clause 26, which talks about immovable property. Again, this is a very, very important definition with respect to your examination. The meaning of the word immovable property is that it includes land, first of all. The second thing is any benefits which are arising out of land. The third one is any things attached to the earth or permanently fastened to anything attached to the earth. So, this is the meaning of the word immovable property. Now, here the word include is used. That means this is an inclusive definition. It can include a lot many similar things. Okay, this is not an exhaustive definition. Okay, so here the first item is land. We understand what is land, right? Immovable property means the property which cannot be moved. So, other items that are included here are any benefits that arise out of land. For example, on the land, let's say there is a lake. On the lake, in the lake, there are many fishes. So, when you go on that land, you can actually fish those fishes. You can take out those fishes, you can sell off those fishes. So, this is a benefit which we derive from that land. Same way, let's say on the land, there are some trees that are growing. On the trees, there are fruits. So, these fruits that you get from the trees that are attached to the earth, this is a benefit that you derive from the land. So, that is the second point. Next is the things that are attached to the earth. Next is the things that are attached to the earth. So, on the earth, if suppose there are trees, there are buildings, then those will also be considered as immovable property. Again, anything that is permanently fastened to the earth. For example, if suppose there is a tank and that tank is properly screwed and it is nicely fixed on the earth, we are going to consider that tank also as immovable property. So, now here the exam question is that let's say on a land there were some timber trees. Okay. Now, these trees are cut off, they are chopped off and then they are sold off. Now, these chopped trees, whether they are going to be considered as immovable property or not, the answer is they are not going to be considered as immovable property. Why? Because they are no longer attached to the earth. Because they can be moved, they are no longer attached to the earth. Therefore, these chopped trees are not immovable property. The next clause we are discussing is clause number 27, which defines imprisonment. What is imprisonment? So imprisonment means imprisonment of either description as per the Indian Penal Code. So Indian Penal Code is not in our syllabus. So as per the Indian Penal Code, whatever is imprisonment properly defined, that is going to be considered as imprisonment under the General Clause Act also. The next clause is clause number 29, which talks about Indian laws. Now Indian laws basically means all the laws that came into the picture before the commencement of the Constitution. So the Constitution came into the picture on 26th of January 1950. Before that, if there were any ordinances, regulations, acts, rules, bylaws, orders, anything like that, then these will be considered as Indian laws. Next clause is clause number 35, which defines month. So here month, we are going to consider it as the British calendar month. So British calendar month starts from 1st January, then we have months January, February, March, April, etc. Right? So these are to be considered as month when we talk about the meaning of month as per General Clause Act. So see, month can be defined differently for Muslim calendar also, for Hindu calendar also. But here whenever we are using the General Clause Act, then as per this clause number 35, month will mean British calendar month. Next clause we are reading is clause number 36, which talks about movable property. What is movable property? So we have already defined what is immovable property. All the property which is not an immovable property, that is a movable property. Very simple, right? So that is the definition which is stated in our General Clause Act for movable property. Next clause we are reading is clause number 37, which talks about oath. The oath shall include any affirmations or declarations in the case of a person by law allowed to affirm, declare instead of swearing. So what is an oath? Oath is when you call upon the divine power and you swear that this is whatever you are going to say after this, it is going to be the truth. That is called oath. So this is the definition of oath as per clause number 37. Next clause is clause number 38. It defines offence. What is the meaning of offence? Well, offence means any act or omission which is punishable by the laws from the time being in force. So if suppose in India there is any enactment, according to that enactment or rules, if suppose there is an act or omission which is to be considered as offence, they are going to consider it as an offence. Now here please note the word act as well as omission is considered. So when we say act, it means doing something or not doing something. When we say omission, it means forgetting to do something, missing out to do something. It's a mistake. So both of these are going to be considered. If they are considered as offence as per any of the existing enactments, then they will be considered as offence under this definition. The next clause we are discussing is clause number 39, which talks about official gazette or gazette. What is that? It is defined as it shall mean the Gazette of India or the official gazette of the state. So when we say the Gazette of India, that means for the central government at a central level, if suppose any act or statute has to be changed, then with respect to that, this publication is called the Official Gazette of India. Whereas, when we talk about state level publications, that means at the state level, if any act has to be changed, if any order has to be passed, if any circular has to be passed, then it is passed in the Official Gazette of the state. Both of these are included in the definition of the word official gazette. Please note, this definition is exhaustive in nature, so it is not going to include anything else. Only these two items are to be included here. Next is clause 42, which talks about person. The person shall include any company, association, body of individuals, whether incorporated or not. So here this definition is inclusive in nature. It says that if suppose this word person is not properly defined in any of the statutes, then we are going to be using the definition of the word person from the General Clause Act, clause number 42. Now here this definition says that person includes a company or an association of person or any body of individuals, whether they are properly incorporated as a legal entity or not, right? So that means apart from that, of course the natural person, of course the trust, of course the registered society, etc., they will also be considered as person. This is an inclusive definition. These are just examples which are stated here, right? More items similar to that can also be added in the meaning of the word person, and this definition has to be used only if that specific statute does not define the word person. Next clause is clause number 49, which talks about the definition of the word registered. So what is registered? So here General Clause Act is defined registered in terms of a document. Okay, a document is considered as registered if it is registered as per the Act or Statute of India. Okay, so registered word is used with reference to a document shall mean registered in India under the laws for the time being in force for the registration of the document. Okay, so when we say registration, it basically means putting that document or that information in public domain, giving that information to the government to keep record. Okay, so when you also give examination of your CA, then you will also have to submit all of your details to the Institute of Chartered Accountants of India. You basically register yourself for a particular examination, could be inter, could be CA inter, or could be CA final, or could be CA foundation, right? So that is called registration. So registration in the General Clause Act basically means that registering a particular document as per the enactment in India. So if I tell you that a document is registered as per the laws of Australia, are we going to be considering that document registered according to this definition? The answer is no. So according to this definition, a document is considered registered only if it is registered as per the laws in India, right? The next few definitions are very simple. In clause number 51, we define rule. So what is rule? Rule shall mean the rule made in exercise of the powers conferred by any enactment and shall include the regulations made as a rule under any enactment. So when we say rule, it basically means the rule relating to an enactment. So let's say we are trying to interpret the Companies Act. Okay, and in the Companies Act, we are trying to interpret the sections of the chapter relating to incorporation of the company. Okay, now in order to interpret that particular chapter, we are using some rules. Okay, let's say in that chapter at specific places, it is stated that the relevant rules are prescribed. In that case, that word rules, what are we going to understand there? What are we going to understand from the word rules used in a particular enactment? Well, we will have to use the rules that are exactly made for that enactment. So if in the chapter of incorporation of a company, in a Companies Act, it is stated the word rules, then we are going to be using the rules relating to incorporation. So we are going to be using the company's incorporation rules of 2014. So that is what this definition says. Whenever the word rule is used in a statute, we have to refer to the rule relating to that enactment. The next clause we are reading is schedule. Again, this has the same meaning. If the word schedule is used in an enactment, then we have to use the schedule relating to that enactment. For example, in the Companies Act, we have schedule 1 to schedule number 7. So if in the Companies Act, it is stated that this should be done as per schedule 3, then the word schedule means we have to use the schedule relating to the Companies Act only, right? So we have to use schedule number 1 to schedule number 7 of the Companies Act. We should not be using schedules which are stated in some other enactment, okay? The next clause is clause number 54, which talks about section. Again, here also section basically means section relating to that act or regulation. The next clause is subsection. Again, this is also similar. When we say subsection, it means subsection relating to a particular section in an enactment, right? The next clause we are seeing is clause number 62, which defines swear. What is swear? Swear with its grammatical variations and cognate expressions shall include affirming or declaring in the case of a person by law, allowing to affirm or declare instead of swearing. Now, swear basically means, again, you are declaring something. You are declaring a fact about yourself, right? Now, here the divine power is not called. You are simply swearing, you are promising that whatever you are going to say, it is a declaration of truth, okay? Next is clause number 65, writing. What is the meaning of writing? Writing shall be construed as to include references to printing, lithography, photography and other modes of representing or reproducing words in visible form. So when we say writing, it does not just mean someone writing on a piece of paper. It can also include photography, it can also include lithography, or it can also include printing. Because all of these are going to be considered as the term writing as per the General Clause Act definition. The next is clause number 66, which defines year. The year has to be considered as British year. So British year starts from 1st January onwards till 31st December, right? So when the word year, simply the word year is used in any enactment and it is not properly defined, then we are going to refer to that word in the General Clause Act, which is clause number 66 definition, right? And here we are going to consider the meaning of the word year as calendar year as per the British calendar. So that means from 1st January till 31st December. So I hope you understand that financial year is different and year is different. Both are differently defined in the General Clause Act. When we say financial year, it starts from 1st April. Whereas when we say simply year, it is a British calendar year, which means it starts from 1st January and ends on the 31st December. So with this, we have covered all the different sections and all the different definitions which are given in your General Clause Act. I hope you have understood this entire revision lecture, and if you have any doubts, you can let us know. So all the very best for your examination.